I'm Brian Farrington. I'm the head of the employment law section at Coles & Thompson, and we're going to have fun and excitement talking about federal labor law today. Okay. What is discrimination? I look out here and I see this lady is wearing a garment that has leaves on it. I hate that. You're fired. Is that discriminatory? It's stupid. It's immoral. It may even be fattening for all I know. But that's not illegal. Because discrimination means more than just taking an adverse action against somebody for a bad reason. It means taking an adverse action against somebody because of their membership in a protected group. If I took action against her because she's a woman, then that would be a different story. That would be legally cognizable discrimination. So, keep in mind that discrimination is an adverse employment action based on membership in one or more protected groups as created by statute. So, we start with talking about the protected groups. Probably the most significant law is Title VII of the Civil Rights Act of 1964. Title VII prohibits discrimination based on the following factors: race, color, religion, sex, or national origin. Interesting stories about the passage of the Civil Rights Act. First of all, it was the object of the longest filibuster in Senate history as the Southern senators fought tooth and nail to try to prevent a Civil Rights Act from being passed. At the time, what everybody was thinking about was the public accommodations part. Anyone who's studied the history of the civil rights movement knows the Montgomery bus boycott, the integration of bus stations and the Freedom Riders, the sit-ins at lunch counters, et cetera, et cetera. Well, now that sort of discrimination, part of Title I of the Act, has largely been eliminated. I won't say entirely, but has largely been eliminated. But Title VII, the prohibition against discrimination in employment, continues to be a fundamental feature of the employment landscape. Another little piece of interesting information. The original bill did not prevent discrimination against women. The phrase "because of sex" was added to the bill by its enemies. They thought, well, you know, we fought against civil rights based on race. We know we're going to lose that. Wait a minute, why don't we put a poison pill in there? Let's also ban discrimination against women. Nobody will vote for that. Ha, fooled them. And Title VII, as passed, did in fact prevent discrimination based on sex. And also, of course, race, color, national origin, sex, and religion. So that's the most important, I think you could say, safely say, the most important piece of anti-discrimination legislation ever passed. Okay, now, in 1976, the Supreme Court was faced with a gender discrimination case involving discrimination against pregnant women. It was a case called Gilbert versus General Electric. In that case, the Supreme Court ruled, in an opinion by Chief Justice Rehnquist, which will come as no surprise to those of you who have followed the history of the court, he said that discriminating against pregnant people was not discrimination against women, was not sex discrimination. 2 years later, Congress said, no, that's not right, and they amended Title VII to add, they passed what's called the Pregnancy Discrimination Act, and they added provisions saying that you could not discriminate against people because of pregnancy. Specifically, it said the term "because of sex" or "on the basis of sex" include but are not limited to. And that phrase, "not limited to," has a lot of weight today, because of or on the basis of pregnancy, childbirth, or related medical conditions. And women affected by pregnancy, childbirth, or related medical conditions shall be treated the same for all employment-related purposes, including receipt of benefits, as other people not so affected but similar in their ability or inability to work. So, we've now expanded the concept of sex discrimination to include discrimination against people who are pregnant. Because, although it escaped Chief Justice Rehnquist, pregnant people tend to be female. All right, now, so you gotta treat pregnancy like any other temporary disability, including health insurance, seniorities. If you're on a seniority system and somebody goes out to have a baby, they gotta maintain their seniority. And the exceptions, what are called BFOQs, are very narrowly interpreted. BFOQ, by the way, is not an obscene phrase. It's an acronym for bona fide occupational qualification. Are there some jobs in which gender or in which the ability to become pregnant are in fact bona fide occupational qualifications? Well, there are a few. One case famously involved people who helped fit women with bras, and they said, yeah, you could make sure those were female. But the most fascinating case along these lines is a case called Gilbert versus, is Johnson Controls, UAW v. Johnson Controls. Very interesting case. Johnson Controls had a battery plant. That battery plant produced batteries. Batteries are made out of lead, and lead, as everyone knows, and as medical evidence proved beyond a shadow of a doubt, causes birth defects. So as a consequence, Johnson Controls had a policy that if you worked at that facility, you could not work in any job in which you could be exposed to lead or could be transferred into a job where you could be exposed to lead, or you couldn't work anywhere near the plant if you were a female of childbearing age. They defined childbearing age to be anybody between 16 and 59 who did not have medical evidence of sterility. By the way, the 59 upper limit, we all know that's stupid, but the lower limit of 16 was because of child labor. You're not going to have any women under 16 working in a factory because that's a violation of the child labor laws. So anyway, this case goes to court. The UAW, the union, United Auto Workers, had unionized the plant. This case goes to court. The district court rules for the company. Pardon me. It gets appealed to the Seventh Circuit. The three-judge panel of the Seventh Circuit reverses the district court, rules for the women. The court, that case is then heard en banc, as we say, meaning that the entire, I think there were 15 judges on the Seventh Circuit at that time. They reversed the three-judge panel and went back to the favor of the company. So it gets appealed to the Supreme Court. And the Supreme Court, was this a tough case? Obviously, the lower courts agonized over it back and forth, but the Supremes showed you why they're the Supremes. 9-0, they ruled in favor of the female plaintiffs. And they said that just because there's a greater risk of birth defects if a woman becomes pregnant, that is no business of the companies. They cannot prevent them from taking those jobs, which of course, parenthetically, were the best paying jobs at the plant. And so the Johnson Controls case stands for the proposition that bona fide occupational qualifications involving sex or pregnancy must be very, very narrowly drawn. Okay, we're going to spend a lot of time, by the way, at the beginning of this on gender discrimination because it has developed over the years into some interesting directions. Okay, let's talk about sexual harassment. So that's the next step in the development of sex discrimination. What do you do in situations where the company hires women, promotes women, but they're subjected to all kinds of misconduct and nastiness by their supervisors? or coworkers, but of course usually it's supervisors. In the mid-70s, we began to develop cases involving sexual harassment. Now, interestingly, these came out of early racial harassment cases. There's some horrifying cases where African-American employees were subject to people hanging nooses on their lockers, alluding to the terrible history of lynching in the South, scrawled KKK on their lockers, vandalized cars, did all sorts of things. And the courts originally couldn't figure out, well, is that a violation of Title VII? Title VII says you can't discriminate in terms of hiring or promotion or things like that. But eventually the courts were able to come to the obvious conclusion, which is that harassment is just as bad as discrimination, is a violation of the law. And then from that, we moved to discrimination and harassment based on gender. And so we get the early 70s, or mid-70s cases, and they codified sexual harassment as two kinds. The first kind is called quid pro quo. That's a Latin phrase. It means this for that. The exchange of job favors for sexual favors. Go out with me and I'll promote you. If you don't go out with me, I'll fire you. By the way, I mentioned this in my earlier presentation. Quid pro quo is Latin, and under American Bar Association rules, if I can say it in Latin, I get to charge more per hour. So, quid pro quo, baby. Now, because it's the exchange of job favors for sexual favors, it must be done by an agent of the company, in this case by a supervisor. And because it's done by an agent of the company is strictly liable. And an anti-harassment policy does not help if quid pro quo happens. Now, obviously, you need to have one, and we'll talk more about that. But the point is that if a supervisor engages in quid pro quo harassment of an employee, the company is strictly liable for that. Because what the supervisor does, the company does. What the supervisor knows, the company knows. Now, the other form of sexual harassment, which is perhaps not as clear as quid pro quo, is called hostile or offensive environment. Now, hostile or offensive environment is a phrase that's frequently misused. I often have clients call me and say, well, so-and-so says that their boss has created a hostile environment. And it turns out that hostile environment means their boss is really getting on them because they don't do their work. Or in some cases, the boss is just mean. You've just got people who are not particularly pleasant. But hostile in this case, just like discrimination, remember we started talking about discrimination means discrimination based on membership in a protected group. Similarly, hostile or offensive environment has to be motivated by protected group membership. I harass you because you're black. I harass you because you're Hispanic. Nowadays, we had cases, I harass you because you're Asian, and I blame China for the COVID virus. Or I harass you because you're a woman. That's harassment that is a violation of Title VII, and action can be taken. Okay, so hostile or offensive environment is unwelcome sexual advances. Now, unwelcome means unwelcome. A consensual relationship is not unwelcome. If two people in a company start dating voluntarily, that's not unwelcome sexual advances. It's still dangerous, and the employer can still monitor to make sure that they're not in a reporting relationship, that they're not spending all of their time making out in the storeroom instead of doing their work, et cetera, et cetera. But the point is, you don't just ban peer-to-peer dating. The other reason that a consensual relationship can be dangerous is if they break up, and one party wants to keep dating and the other party doesn't, and all of a sudden now, the advances which were previously welcomed ain't welcome anymore. And of course, you should always forbid, as a company, supervisor-subordinate dating. The obvious dangers of quid pro quo are there. When a supervisor asks a subordinate out, is it really just, personal attraction, or is there some pressure or leverage based on the fact that this is a person who is in a position of authority? All right. And this, while it's not a violation of the law, is a morale thing. There's a perception of favoritism. One of the most interesting sets of cases are paramour cases, and that's the term the courts use. So let's say I'm dating my secretary, which is obviously highly implausible since I'm old, I'm fat, and I've been married for 49 years, so that's not happening. But if I were dating my secretary and I promoted her, it would be obvious to everybody else who was a candidate for that promotion that she had an unfair advantage. And even if she were the best candidate, it would still look like favoritism. So those are called paramour cases. If I favor my paramour over other employees, that's not a violation of Title VII. It's bad management is what it is. All right, moving on. You cannot forbid or should not forbid coworkers to date, but you can apply nepotism rules. So the same rules that say you don't have uncle and nephew, that's the classic nepotism, or husband and wife in a reporting relationship, you don't have lovers in a reporting relationship. Now, sexual harassment is also unwelcome, again unwelcome, verbal or physical conduct of a sexual nature. So it can be sexual advances, which can be anything from, pardon me, would you care to go out with me Saturday night, to, hey baby, let's get it on in the storeroom. Obviously one's a lot worse than the other, but those are sexual advances. The other is conduct, verbal or physical, of a sexual nature. So there's some strictures to that. Unwelcome means both objectively and subjectively. Objective means, well, let's say subjective means I feel offended. But objective means any reasonable person in the place of the victim would be offended. What we don't want to have is someone who is hypersensitive and objects to conduct that no reasonable person would object to. I got a call once from a museum up in, I think it was Minnesota, many, many years ago. And I said, oh, we have this problem. This woman is complaining about one of her coworker who has some pictures on his desk. And I said, well, what's the pictures? Well, apparently the coworker and his wife went to the Caribbean together, and they went out on boats and, did the things you do when you're in the Caribbean. And there's a picture of them on the dock, arms around each other in their bathing suits. And this coworker was horribly offended that this guy had a picture of his wife in a bathing suit on the desk. I said, okay, here's my legal analysis. Tell her to get a life. Because no reasonable person in the place of the victim would have objected to those pictures. Now, it's another thing if there's boudoir photography or nude photographs or whatever, sure. But the mere fact that I'm offended does not end the analysis. I'm offended, and it's reasonable for me to be offended. That's that standard. Okay, now, the conduct must be serious or pervasive, not isolated or incidental. Physical conduct is serious. It's ancient history now, but how many of you remember Clinton v. Jones, the Paula Jones lawsuit against then-President Bill Clinton for conduct that was alleged to have occurred while Clinton was the governor of Arkansas? Ms. Jones was the lowest level employee in the state of Arkansas. I mean, basically she was somebody who worked for the Development and Tourism Department. And there was a conference, kind of like this conference, and she was at the desk. And the governor came by, and the governor found her quite attractive and asked her to come up to his suite. So far, this is agreed upon. Everybody agrees that this happened. What happened when they got up to the suite is a different story. She says that he took off his pants and invited her to perform a sexual act upon him. He, of course, denied it, said that never happened. The case went to trial, lawsuit filed 1 day before the statute of limitations expired. Case goes to trial, and the court grants summary judgment for Clinton and says even if the conduct occurred as Jones described it, standing alone, that one incident was not serious, and of course, it only happened once, so it was not pervasive. Now, opinions might differ as to whether or not that conduct, if it happened the way Jones said it happened, whether that would be serious in itself. I suppose it depends on if you're the one in the hotel room, right? But the judge said, even if that's what happened, we're dumping the case. Now, it was appealed, and while it was on appeal, Clinton's insurance company paid a bunch of money before the appeal could be heard. But the idea was it's got to be pretty bad in order to be serious under the law if it only happens once or a couple of times, and typically that involves physical conduct. I had a case once where a guy ran his hand up under a woman's dress. That'll do it. That's serious. But it doesn't have to be that bad. It can be low-level stuff if it keeps happening, pervasive. So if I go to a coworker and I say, pardon me, but you're quite attractive. Would you care to go out with me Saturday night? You know, she might say, that's sexual harassment. You can't do that. No. I mean, that's, again, no reasonable person would find one time to be offensive. But if it happens all the time, if I'm constantly hitting on her, then at some point, the conduct becomes pervasive and becomes sexual harassment. So hostile or offensive environment is unwelcome conduct, verbal or physical, of a sexual nature, which is either serious or pervasive. Okay. And verbal comments on body, clothing, appearance, dirty jokes, vivid descriptions of your love life, or pointed questions on her love life, those things can all amount to sexual harassment. I even had a case once where a woman had filed an EEOC charge because her boss, among many other things that he was alleged to have done, had a novelty plant in his office, the leaves of which were made out of condoms. Really classy guy, right? And we settled that case. We didn't want that one to go any further than it had to. All right, now, employers must protect their employees even against third-party harassment. So if the copier repairman comes in frequently, as is often the case, and constantly hits on the receptionist every time he's there, the employer may not have any authority over the copy repairman, but he is responsible, or they are responsible, for protecting their employee from being harassed by third parties, and action must be taken. Whether that's a phone call to the repairman's boss or whatever, it has to be done. I once had a client that was in the staffing business, and they got a call from a major client who said, don't send us any more black employees. We don't want any black applicants. And so my client called me up and said, you know, what am I going to do here? You tell them to go to hell. You are not going to go along with that, even though it's important business. But after that, every time anyone filed a discrimination complaint against that client, I always said, and you know what else? They turned down a big client who was racist. And so, you know, it gives you some credit, right? It's nice to do the right thing. It's nice to get some credit for doing the right thing, and that's what in fact happened. Okay, now, what is the company's liability for sexual harassment? I already pointed out that the liability for quid pro quo, total. Now, for hostile environment, if it's done by a coworker, it's really what we call a negligence standard. So if Sally harasses Sam or Sam harasses Sally and their coworkers, it's not the company's fault if the company didn't know of the conduct and had no reasonable way of knowing. And one way the company defends itself is you have an anti-harassment policy in place where a complaint mechanism is there, and unreasonably the company does not, the employee doesn't take advantage of it. I didn't know it was happening because you didn't complain. If you'd complained, I'd fixed it. Well, we hope that that's true, but that is a defense. Now, the employer can't walk through the company with blinders on, if I don't see it, it didn't happen. The company is responsible for exercising reasonable diligence in detecting sexual harassment if it's happening. But if the company exercising diligence doesn't know about it, they don't have liability. That's different if it's a supervisor. Because remember what I said earlier, that if a supervisor acts, the company acts. So if a supervisor does hostile or offensive environment and there is a tangible job detriment, and that's the words of the Supreme Court. So I harass somebody so badly they quit. Or I harass somebody, she doesn't give in to my advances and I transfer her or demote her to a worse position. Then strict liability. But if the supervisor does it and there is no tangible job detriment, the company stays liable but can raise an affirmative defense to damages. The affirmative defense is that there was an I showed it earlier, an anti-harassment policy and a complaint mechanism in place, and the employee unreasonably failed to take advantage of it. Now note unreasonably. Let's say that the employee who is harassed by a supervisor knows 7 coworkers, all of whom got harassed. They all complained and the company never did anything. Well, then it's reasonable for her not to complain, right? Because she knows it's futile. But if it's unreasonable for her not to give the company a chance to fix it, then the company can avoid damages. So supervisor does it, job detriment, strict liability. Supervisor does it, no job detriment, company's liable but can defend. And its defense is, we had this wonderful harassment policy in place. We'd have fixed it if we could. You didn't complain, and it was unreasonable of you not to complain. Okay. Now, recent developments. This is why I'm spending a lot of time on sexual harassment and sex discrimination in general, because we've had a lot of important developments. Employees can no longer be forced to take sexual harassment complaints to arbitration. This is one of the biggest complaints that employee organizations and plaintiffs' lawyers have had for a long time. You know, these days everybody has to sign an arbitration agreement. How many people here work for companies that have arbitration agreements in place? I see a few hands. There's probably more who don't want to admit it. But famously, there was a lot of heat on Jimmy John's, the sandwich makers, because they made their sandwich makers sign arbitration agreements. Like, if you try to take your sandwich to some sandwich making techniques elsewhere, that kind of thing. But sexual harassment now, even if there is an arbitration agreement in place, it is trumped by the law. And they can demand that they have a jury trial in front of an Article III court, and employers don't like that, but that's what happens. The other thing that employees have been complaining about are NDAs, non-disclosures. Famously, for example, President Trump makes everybody sign non-disclosure agreements. If there's a settlement of a sexual harassment complaint, so Sally files a sexual harassment complaint against a company. The company realizes, we better get out of this one, and they offer her a settlement, but they insist on a confidentiality clause. I've settled hundreds of cases. I always have a confidentiality clause. Can't do it in sexual harassment anymore. Well, you can, but if you do, guess what? The amount of the settlement itself and the attorney fees are not tax deductible. So it suddenly becomes really expensive to you if you insist on covering it up. Now, this is controversial. It's brand new. It only took earlier this year, I think, maybe late last year. And a lot of employees don't like it. At first it seems, that's great, we should punish them for hiding their misconduct. Think about, Harvey Weinstein and the Me Too movement and all that. But if you're an employee and you settle a sexual harassment complaint, do you really want every future company that you're applying to know that you were involved in one of these actions? Maybe you do. But if you don't, you may not have a choice. And obviously, companies really don't like to admit that their, manager of operations is a perv, and so they really prefer to have non-disclosure agreements. But that's the new aspect, and this is at the federal level. Now, here in the state of Texas, there's been some real changes. Title VII at the federal law applies with 15 employees. Used to apply, and it still does apply to the Texas law as well in every other aspect. But right now, the 15-employee coverage doesn't apply in sexual harassment. You could have one employee. You harass that employee, you got a problem. And this is a kicker, supervisors can be personally liable for harassment. Now, at the federal level, at a wage and hour case at the federal level, supervisors can be sued personally. But not under Title VII. Not under an EEO thing. The company can be liable, but the individual supervisor, the individual harasser, for example, can't be liable. But now in Texas of all places, super conservative, bright red Texas, there's personal liability on supervisors who are guilty of sexual harassment. So if you don't want to get a bill for several $100,000 in lost wages and compensatory and punitive damages, don't harass your employees. Word to the wise, pro tip, don't harass your employees. Okay, now, this slide kind of got out of place. I mentioned this before. The affirmative defense that companies assert is that they have a widely disseminated and effective internal complaint process, and that the employee unreasonably fails to take advantage of it. I make reference to Boca Raton. There were a pair of cases that the Supreme Court decided some years ago that came up with this structure. One was Farragher, and the other was Ellerth. I think Farragher versus Boca Raton and Ellerth versus somebody else. But the Boca Raton case is interesting because it demonstrates how dangerous it is if you don't train your first-line supervisors. The city of Boca Raton, Florida, had lifeguards. It's a beach town, and people go swimming in the ocean. And apparently, and here's a reference that shows how old I am, apparently the way the lifeguard outfit worked is kind of like Baywatch. Right? You had all these handsome, well-built men and women, all very young, all sexy, and apparently things got out of hand. Well, this one lady, Ms. Farragher, 19 years old, was constantly harassed out there, and she went to her supervisor and complained. Now, her supervisor was a grizzled old veteran of about 22, and he said, "Oh, cool, dude, whatever, just live with it." And then a few months later, 3 or 4 months later, when the conduct continued, she went to the city manager. Well, the city manager, having a little more experience than the dude in the lifeguard outfit, promptly acted to solve the problem. But it was too late. The courts held that because the company did not act promptly to resolve this situation, there was no defense available to them. This is why the lesson here is every supervisor, down to the lowest level supervisor, the foreman, the crew leader, whatever, has to know enough about sexual harassment law to know when to say, I better go talk to my boss about this. The crew leader may not know enough to fix it, but the crew leader should know enough to say, possible problem, better go talk to the district director or the operations manager or whomever it might be. So prompt remedial action if you're going to have any kind of defense. All right. Now, same-sex sexual harassment, and this is leading somewhere. There's a famous case out of the Fifth Circuit here called Oncali versus Sundowner Offshore Oil Services. At that time, the legal position and precedent in the Fifth Circuit, which is our circuit, was that same-sex harassment did not violate Title VII. Well, Mr. Oncali was a small, soft-spoken, slightly built young man who went to work on an offshore oil drilling rig. Bad choice, right? I don't know if you know much about the oil business or the oil business, as we say, but it is the only business I know where roughneck is an official job description, all right? And Mr. Oncali was brutally treated by his coworkers because they perceived him to be effeminate. He'd have, in the shower, they'd threaten to rape him. They did all kinds of horrible things. And Mr. Oncali had a problem, or rather his lawyer had a problem. Who are you going to sue? You going to sue the coworkers? Well, oil workers get paid on Friday. By Monday morning, they got nothing left. So day one in law school, they teach you do not sue insolvent defendants, but you can't sue the company because in Title VII precedent in the Fifth Circuit is it doesn't violate the law. But he did it anyway. And of course, the Fifth Circuit ruled against him. But another circuit had ruled that same-sex harassment was forbidden. So when you got a split of authority between two courts of appeals circuits, then it can go to the Supreme Court, and it did. And again, the Supreme Court showed why they're the Supremes, 9-0. They supported Oncali. And the opinion was by Scalia, one of the super right-wing conservative justices. But the court said, EEOC has taken the position that existing sex discrimination protects such people, and I took that long quote out. Maybe I shouldn't have. But anyway, Oncali said that the conduct in question must be severe, not horseplay. They used the example, Scalia being a colorful writer, that if the coach slaps a football player on the butt to send him out to the huddle, that's one thing. If you slap your secretary on the butt, that's quite another. But basically said that perception was the key. The reason they harassed Oncali was because he didn't live up to their image of what a man should be. So it was conduct because of sex, right? Because of the perception of what a male versus a female should be. Well, guess where that train of reasoning led? Okay, that led to Bostic County, which is the new case we'll talk about. So EEOC has always said that Title VII protects LGBT employees, but Congress never has amended Title VII. To this day, Title VII does not say it protects sexual preference or transsexual, transgender status, etc. But there was a case in '89 called Price Waterhouse v. Hopkins. A woman who was an excellent CPA. Everybody said she did a great job working for Price Waterhouse. Company said, yeah, but we don't like the way you interact with our clients. You're too masculine. You should go to charm school. That's on one of her performance appraisals. She needs to go to charm school. Well, the court said that's because of sex, because she didn't meet the traditional image of what a woman should be. Well, then you get Oncali comes after that. We are beyond the day, said the Price Waterhouse Court, when an employer could evaluate employees by assuming or insisting that they match the stereotype associated with their group. For in forbidding employers to discriminate against individuals because of their sex, Congress intended to strike at the entire spectrum of disparate treatment of men and women resulting from sex stereotypes. Well, I'm not sure Congress did in fact mean that, But that's what the Supreme Court said, and their understanding of the term because of sex had deepened and had increased. Okay, then we get on Colley. Supreme Court said males harassing another male who was perceived not to meet the traditional image of masculinity was harassment because of sex. We talked about that. And then Congress has never amended Title VII. I mentioned that. Protection of gay and lesbian employees from sexual harassment is well established under on Colley. But protection of LGBT employees from general discrimination was not clear until 2020. On 4/22/19, the Supreme Court announced that it would grant cert in Altitude Express v. Zarda out of the Second Circuit. The Second Circuit found Title VII protected LGBT employees, whereas the 11th Circuit had decided in Bostock versus Clayton County the opposite conclusion, and that gave the court the chance to hear it. Zarda is an interesting case, by the way. Mr. Zarda was a skydiver, and he worked for a company that would take you up and jump out of a plane with you. And so he went up with a couple, and he was the one who was helping the wife. And, you know, you got to hook yourselves together and hold on. And he made some passing remark to the husband, "Don't worry about this, I'm gay." Meaning, don't worry about the fact that I'm holding tight onto your wife because I'm not really interested in women. Well, somehow this offended the husband who complained to the employer. The employer fired Zarda. And Zarda's case went to trial. And then it went up on appeal. Unfortunately, Mr. Zarda was not there to enjoy the victory at the Second Circuit because one day his parachute didn't open and he was dead. But his estate carried on the case. And so now you got Zarda, you got Bostock, it's a split of authority. By the way, the Fifth Circuit in a case called Whitley was staunchly against protecting LGBT employees. Seventh Circuit had a case called Hively, and they were in favor of it. So you had several cases on different sides. In Bostock, the court issued a somewhat surprising 6-3 decision overturning the 11th Circuit and previous similar cases. They ruled that the protection in Title VII against discrimination because of sex, those prohibitions do protect LGBT individuals. The court said, the statute's message for our cases is equally simple and momentous. An individual's homosexuality or transgender status is not relevant to employment decisions. That's because it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Now that opinion was by Anthony Kennedy, who has since left the court, replaced by Kavanaugh. In the wake of Dobbs, the case overturning Roe v. Wade, a number of conservative commenters have suggested that the court will come after Obergefell, which is the same-sex marriage case, and may well come after Bostock and try to overturn that. I don't know. I don't have a crystal ball when it comes to the Supreme Court. But as for now, theoretically, even if Kavanaugh went the other way, you should still have a 5-4 majority for the outcome in Bostock, but who knows? But anyway, so now we see that the phrase "because of sex" expanded to pregnancy, expanded to harassment, expanded to same-sex harassment, and has now expanded to all LGBT people as well as traditional sex roles. So I suspect that when Congress wrote the law in 1964, they didn't mean all of that, but their words clearly can apply in the way the courts have applied them. All right. Now, after all that, let's talk a little bit about religious discrimination. And all I got to say about religious discrimination is you clearly cannot discriminate against people. You know, there's no Jews need apply or we don't hire Catholics here. It's not going to fly. unless you're a religious organization. I mean, you know, a church can require that people be members of that church if they're going to be employees, and that extends to schools as well. So if you're a Baptist school, you can hire Baptist teachers, you know, but outside of that, discrimination against people because of religion is not permitted. The real issue that comes up in a day-to-day is religious accommodation. I don't know how many of you were in my class this morning where we talked about COVID, but one of the things that came up was religious exemptions. And if you asked for a religious exemption from a vaccination requirement, the employer doesn't have to grant it if it's more than a de minimis cost. And that comes out of a Title VII case called Hardison versus TWA. Apologize to those of you who heard this before, but for those who didn't, TWA was an airline, and it was a union airline, and they assigned shifts based on seniority. To get a Monday through Friday shift and not have to work the weekend, you had to be there 15, 20 years. Well, Mr. Hardison went to work for TWA. This was no problem for him for a couple of years. Then he converted to the Worldwide Church of God. The Worldwide Church of God recognizes a strict Saturday Sabbath, just like Seventh-day Adventists or Orthodox Jews. And Hardison said, you got to give me Saturdays off. I can't work on the Sabbath. And the company said, well, yeah, but the problem is we got a seniority system, and if we give you that accommodation, we're screwing up our seniority system. Went all the way to the Supremes, and the Supremes had no problem saying that that for religious discrimination, if it's anything more than a minimal cost to accommodate, the company doesn't have to do it. Under ADEA, reasonable accommodation, you really have to have an undue hardship means it's really tough not to accommodate. But under religion, you don't have to have much hardship at all to get out of the accommodation. Why? First Amendment, right? Congress shall make no law establishing a religion or prohibiting the free exercise thereof. If you go too far to support free exercise, to support Mr. Hardison, you're establishing religion. If you go too far with the establishment, you may be prohibiting somebody in an unusual religion from free exercise. So you got to balance, establishment clause, free exercise clause, and that's how the court came down on this. All right, age discrimination. For the past 30 years, I've been in the protected age group, which says that you may not discriminate against people age 40 and up. That's the protected group. There is no reverse discrimination. I mean, if you say, I only want old people like Brian, I don't want young people, well, that's okay. My experience is that doesn't happen much, but that would be okay. But you cannot discriminate against persons who are in the protected age group, which is 40 and up. Now, and that applies at 20 employees. In Texas, though, it's 15 employees, so the stricter standard applies. Now, the biggest impact of ADEA is that there is no mandatory retirement, with some public sector and safety-related exceptions like airline pilots. The law has been amended back and forth several times on whether you can have mandatory retirement. There is a provision that if you're entitled to a golden parachute, you know, some big retirement plan, you can be involuntarily laid off, but most employees cannot. The exception are safety things like airline pilots. This example is, like a lot of my examples, dated somewhat. But some years ago, there was an airline pilot who was flying over Hawaii when 27 feet of the fuselage blew out at about 20,000 feet. Amazingly, the pilot landed this plane safely. A flight attendant was killed, sucked right out of the hole. It was a terrible thing. That pilot was aged 59 years and 7 months, and this was scheduled to be his last flight. Maybe I should update it. Sully Sullenberger was, 59 years old when he miraculously landed that jet in the middle of the Hudson River. Nobody was killed as a result of it. So can you really say that at age 60, magically, nobody's qualified to be a pilot? The answer clearly is no. But what the courts have consistently said is, statistically, the likelihood of you suffering a stroke or a heart attack or some other impairment that would create an in-flight emergency is a lot greater when you're 60 and above, and so the courts have upheld that. Because they don't want some 62-year-old guy having a heart attack and crashing a plane. You know, that's basically what it amounts to. But for most people, there's no mandatory retirement in the United States. All right. The most common claim is older worker replaced by younger worker. You know, you fire some guy who's not doing a good job. You hire some guy who's, 27 years old to replace him, and the older employee says, it's age discrimination. And clearly you have to be able to establish that, in fact, he wasn't doing a good job and that the 27-year-old was the best possible candidate. But the comparable doesn't have to be like 62 and 27. If there's 10 years difference, there can be a complaint. So if a 59-year-old is laid off and replaced by a 41-year-old, even though the 41-year-old is in the protected group, that's still a cognizable sexual harassment charge and has to be investigated and could be litigated. All right, ADEA. This is the most recent of the anti-discrimination laws in that it was passed and signed in '92. The ADEA again applies at 15 employees. General rule, no discrimination against qualified individuals with a disability. What constitutes discrimination under the ADEA? In addition to the obvious, I don't want to hire you because you're in a wheelchair, or I make fun of you because you are, not making reasonable accommodation to the known physical or mental limitation of an otherwise qualified applicant with a disability who is an applicant or employee, unless such covered entity can demonstrate that the accommodation would impose an undue hardship. And undue hardship means really tough. What is a disability? It is a physical or mental impairment that substantially limits one or more major life activities, or a record of such an impairment, or being regarded as such an impairment. The 3 R's: real, record, regarded. Sometimes the 3 P's: present, past, perceived. This is so weird. I mentioned this again this morning when we were talking about COVID. I can't make you black or white or Hispanic. I can't make you male or female. But I can make you disabled simply by regarding you as disabled. So let's suppose I have a bad burn scar on my face, and you run a high-fashion boutique, and you don't want somebody who looks like me working in your store. Even though that impairment doesn't in fact prevent me from doing anything as a retail employee, you apparently regard it as a disabling condition, and you have made me eligible now to make a charge of discrimination under the ADA. It's kind of remarkable. Qualified individual means somebody who, with or without reasonable accommodation, can perform the essential functions of the employment position that such an individual holds or desires. Now, let's say I can't drive. I have some physical or mental reason that prohibits me from driving. Well, obviously, if you don't hire me to be a truck driver, you're going to win that case. But what if you like it to be able to occasionally toss me the keys at lunchtime and say, go get burgers or pizza for the crew, and I can't do that? Well, that's not an essential function. So my inability to do a non-essential function doesn't even enter into the conversation. Applicants and employees must be otherwise qualified, meaning they meet the other qualifications for the job. An employee with a disability who applies for an accounting position but has no education or training in accounting is obviously not otherwise qualified, and we don't even have to get to the question of that employee's disability because they're not otherwise qualified. All right. Now, Texas state law generally tracks the federal law, with that amazing exception where you've got sexual harassment, personal liability. Other states have similar laws, but many cover employers of fewer than 15. All right, so where are we? I've spent a lot of time, maybe more than I should, talking about who is protected by these laws. What are the protected groups, membership in which make discrimination and harassment a violation? You've learned that that includes race, color, national origin, sex, religion, age if you're 40 or up, and disability, qualified individual disabilities. Knowing that background, let's talk a little bit about, from a practical purpose, what does that mean when you're hiring people? What does it mean when you're firing people? And then we'll talk about what you have to do or can't do when you're responding to a charge of discrimination. Okay, when you are hiring employees, a general rule on applications and in interviews is if you need to know, ask. If not, don't. So I know the management textbooks all tell you to have wide-ranging interviews and to ask big open-ended questions, but there's a lot of questions that you kind of want to not ask. For example, do you really want to say, is there any reason why you can't work weekends? Yeah, I'm an Orthodox Jew and I can't work Saturdays. Ooh, I didn't want to know that. What I wanted to know was, this job occasionally requires work on weekends. Can you do so? Yes. Can you do so? No, because I don't even want to know why you can't. I just need to know that you can't. So I'm being a little facetious here, but it's important that you focus on what's relevant to the job and don't wade off into people's personal lives any further than you need to. Age, date of birth, you should only ask these things for child labor purposes, and you may need to know it if you do background checks. But, you know, in the old days, they used to say, how old are you? Well, I'm 57. Well, I ain't going to hire you. You can certainly ask if the person looks like they're about 12. You could ask how old you are, because we don't want to violate the child labor laws putting you to work. And admittedly, as more and more employers utilize background checks, you kind of have to have date of birth, especially if the person is named Jane Doe. You kind of really want to be able to distinguish that Jane Doe from all the other Jane Does. You never ask about race. You never ask about religion unless you're a religious employer. You never ask about national origin. Oh, I notice you're pretty dark complected. Where'd you come from? I came from Texas. You know, the fact that my parents might have been born in India or Vietnam or someplace else, you don't ask those questions. That's stupid, stupid, stupid. Don't ask for photos. I had a case years ago in deep East Texas. Those of you who are from Texas know what I mean when I'm talking about deep East Texas. And at this particular employer, it was a chain of fast food places. And the local managers could hire you for regular positions, sight unseen. But if you applied to be an assistant manager or manager, they had to send your application to the home office for consideration with a photograph. Well, somebody said, I think they're using that photograph to weed out the black applicants. And I don't know if they were or not. They said they weren't. But more importantly, I did a regression analysis. Now, if you ask me what the heck a regression analysis is as I sit here today or stand here today, I don't know. But I knew enough to go look in a book, and the book said that if you're going to decide whether or not the hiring patterns, what percentage of applicants are minority versus non-minority, what percentage of those that you hire are minorities versus non-minorities, here's the formula. And I applied the formula. And by golly, it came out okay, and we won that case. But the fact is, when the EEOC hears that you're asking for photographs of applicants, that's going to raise a major red flag. This employer probably wasn't intending to discriminate. They certainly didn't admit it to me if they did. But generally speaking, employers who ask for photographs are asking for discrimination charges. Now, once they're hired, if you want to do stuff like that, that's okay. Now, under the ADA, every applicant should be given an essential function job description. Not just, I'm hiring you to be a cook. Here's our written job description, and it lists all of the things you're going to do and how much you have to lift and whether you can walk on slippery surfaces and whatever it may be. I have a lot of clients who, when you come apply for the job, they will give you the job description and say, sign here saying you can do this, or do you need a reasonable accommodation to perform these essential functions? And if so, we'll talk about it. That's the way you're supposed to approach it. That way, if somebody does need an accommodation, you know up front and you can talk about it. Only ask if they can perform essential functions. You don't suggest accommodations, they have to initiate it, but then you have to talk. Crazy example comes to mind. Let's say somebody rolls into my office in a wheelchair and I'm hiring people to climb radio towers. Well, it doesn't look to me like that person might be able to do it. So I can ask that person if they can perform that function. I can even ask them to, according to the law, demonstrate or describe how they're going to do it. Now, I sure as heck don't want them to try to demonstrate that because I don't want them suing me when they fall. But the point is that you're only interested in whether they can perform the essential function, and if they say, I can't do it without an accommodation, but I can do it with, that's the time you talk about reasonable accommodation. The law says you must enter into a flexible, interactive process, and you can lose ADA cases simply because you didn't talk about accommodation. Not because you didn't grant an accommodation, because maybe you couldn't, but you didn't talk about it. And if you don't talk about it, that's a violation. All right. Ask about education only to the extent that it's relevant. And this goes back to one of the most famous early Supreme Court cases in Title VII history, Griggs versus Duke Power Company. Griggs versus Duke Power Company is the case that introduced the concept of disparate impact. Disparate impact means I have a criterion for employment that appears on its face to be neutral, but in practice screens out more of one protected group than another. In the late 60s in North Carolina, Duke Power Company in the 50s and 60s didn't hire blacks at all. They just didn't. Starting July 2nd, 1965, they started hiring black people. Purely a coincidence that was the effective date of Title VII of the Civil Rights Act, right? Well, they started hiring black people for low-level positions like janitor, and they demanded that they have a high school education. In North Carolina, in 1965, only 12% of black people had a high school education. Now, only 36% of whites had a high school education, which does not speak well for North Carolina's educational system. But the point is that after a century or so of Jim Crow and separate but equal and all of that nonsense, the high school diploma requirement screened out more black applicants than it did non-black applicants. And so the question is raised, was there a good reason for having that? Did you need a high school education to be a janitor? Answer, no. So it became illegal. And the whole concept of disparate impact comes from that case. If I'm hiring accountants, can I require that they carry a 100-pound sandbag up 5 flights of stairs? No. The requirement must be job-related and consistent with business necessity. If I'm hiring firefighters, can I make them do that? Yeah, it's probably right, because I'm measuring an ability that can come up in the performance of the job. And if Sally is the 100-pound person that needs to be carried out of a burning building, we kind of need to know that this applicant can do that. But if you give a typing test, and I know I'm dating myself, now it's a keyboarding test. If I give a typing test to somebody who's going to be a secretary, sure, that measures something that's done on the job or predicts success on the job. But otherwise, you limit the testing, you limit the criteria, you limit the questioning to things that are relevant to carrying out the job. So that's the education thing. Don't ask about gender, don't ask about marital status, don't ask about family. This is a big one, by the way, because here's another one. You have kids, right? Well, are you going to be able to work late if we need you? It's another one of those things I didn't want to know. How about this job occasionally requires you to work late, work overtime on short notice. Can you do it? Yes, I can. Can you do it? No, because I don't want to know why you can't. I just want to know whether you can or can't. That's discriminatory in a lot of ways because in our society still, the majority of child care burden falls on women. And so if you have a criterion that tends to exclude more women than men, you've got a problem. All right. Arrest, conviction, deferred adjudication. You may ask about convictions only. You got to have a disclaimer, and of course, under Fair Credit Reporting Act, data about lawsuits, et cetera, can't go back to more than 7 years. This doesn't apply to actual convictions. You know also that the EEOC says that in considering convictions, you're supposed to consider the nature of the job, how long ago the conviction was, and what the conviction was for. The Fifth Circuit rejected the EEOC's guidelines, but those are principles that you should follow. It's one thing if you want somebody to be a maintenance worker and get keys to people's apartment, and he was convicted of rape or assault or something. I don't think so. On the other hand, if you get some guy 20 years ago, he was convicted of shoplifting, and he's led an exemplary life thereafter, then that you probably should ignore that. Because remember, in our society still, minorities tend to be arrested, tend to be convicted far more frequently than non-minorities. So it's a disparate impact question. You can still ask a disparate impact question. It's just got to be job-related and consistent with business necessity. So the fact that convictions may have a disparate impact on minorities, if the conviction is for something that really raises serious questions, then it's okay. That's consistent with business necessity. Yes, sir. Pardon me? The EEOC takes a position that credit checks, for example, can have a disparate impact. More minority people tend to be poor than non-minority people. On the other hand, broadly speaking, there's probably a lot of business necessity justification. But I would consult with your lawyer and talk about that on a case-to-case basis. Because it's possible that you could have a problem. Probably not, but possible. All right, do you ask about wage garnishments? I know as payroll people, you know what a pain in the tuchus it is to have to deal with garnishments, but you can't use that you can't make that inquiry. You can terminate people for multiple garnishments for different indebtednesses. You can't do it for multiple garnishments for the same indebtedness. But as we all know, that's one of the toughest things in payroll. You can't ask about bankruptcies. You cannot ask about citizenship. Now, if you're a police department, some of this stuff doesn't apply. But you can't ask about citizenship. What you can ask is, in compliance with the Immigration Reform and Control Act of 1986, we require all employees to demonstrate with documentation their identity and their eligibility to work in the United States. The I-9 form, right? If hired, can you present such documentation? That's a legitimate question. I mean, clearly you're not going to hire someone if they don't have documentation of their identity or of their eligibility to work, but you can't ask about citizenship because lots of non-citizens have work authorization. On your application form, you should have an EEO statement. You should authorize any testing you're going to do. You should say that misleading, inaccurate information or omissions are grounds for rejecting the application or for terminating you if we find out about it later. You should authorize previous employers, schools to provide information and release them from liability. And like everywhere else, you should have a statement of at-will status. Pre-employment inquiry guide. The EEOC in a number of states have a listing of what you can and can't ask. Rather than try to, pull it out of the air, get a hold of the EEOC's pre-employment inquiry guide. It'll tell you what you can and can't ask. It's a good thing to have. Retain all applications and resumes for a year. You cannot give lie detector tests. You can do some psychological testing, personality profiles, but be careful about ADEA implications. And as we talked about, you can have credit reports, but you got to be able to justify it as a matter of business necessity. Let me mention this psychological testing. I had a client once, I don't have them anymore, who, if you were going to get promoted to manager, they would test you. They would apply what's called the Minnesota Multiphasic Inventory, the MMPI. Now, this is a diagnostic tool that's used to determine mental illness. And it was clearly a medical exam. And I told them, you shouldn't be using that. Well, they went public, hired some big law firm, and boy, did they get the heck suit out of them. So it's okay to do some of that testing, but be careful what you do. All right. Remember that the general rule in Texas is employment at will. Employment at will means that either party to the employment relationship can terminate it for any reason or no reason at all. Now, the employment at will doctrine seems harsh, and in some ways it is harsh. It's better than what it replaced: slavery, indentured servitude. We had some bad stuff before, but employment at will is the general rule in Texas. It goes back to an 1890-something case called East Line Railroad. It's the general rule in most states, not all states. Some states, notably places like California, basically you have to have a good reason to fire people. Texas, you can fire them for having bamboo leaves on their shirt, that kind of thing. But just to say Texas is an at-will state doesn't end the process, of course, because there are many, many limitations on employment at will. The most obvious one is what we've been talking about for the last hour: federal and state law. I can fire you for any reason or no reason at all, but I can't fire you for your race, sex, age, religion, national origin, all that stuff, obviously. Be careful of falling into contracts with employees that they may bring up when you try to fire them. Now, what do I mean by an accidental contract? Most of you are far too sophisticated, and this is old stuff, but don't use terms like permanent status. You've been here 90 days, you're over your probationary period, now you're a permanent employee. Yeah, I don't want you to be a permanent employee, you're an at-will employee. Disclaimers emphasizing employment at will are usually effective in Texas. Supervisor comments. Famous case involving Ford Motor Company where basically the boss said to this group of employees, I don't care what the manual says. As long as you do a good job, you got a job with us. Well, they laid them off and they said, hey, you made us a promise. And the court at that time said, yeah, they made them a promise, it's a violation. So now, of course, the case law says there must be a clear and unequivocal promise of job security. Any of the laws that we're talking about, plus a bunch of other laws, have retaliatory discharge prohibitions. Somebody files a complaint under FLSA or the National Labor Relations Act or Title VII, et cetera, and you fire them because of that, that in itself is a violation. And I have to emphasize this to clients because somebody files a complaint of discrimination that's bogus as it can be. And we win on that complaint. But if the employer turns around and retaliates against that employee, then we lose that one. In other words, employees have a right to be wrong about whether or not they have been discriminated against. Okay, when you're going to go fire someone, I suggest you be analytical. Think about the consequences of what you're going to do. Have you given them a warning and a chance to improve? Unless they took a swing at their supervisor or showed up drunk or something like that. Have you adequately documented it? Document, document, document. Louis B. Mayer, one of the founders of Metro-Goldwyn-Mayer Studios, was famous for his malapropisms. And at one point he said, an oral contract isn't worth the paper it's written on. Well, Louis may have gotten the details wrong, but essentially he was correct. If you're going to fire somebody, I want to see a written paper trail, unless it's just a sudden blow-up. I mean, if the person comes in and starts shooting, well, then you can go ahead and get rid of them, but I like to see adequate documentation. Have you been consistent with your own policy? Our policy says oral warning, written warning, termination. This guy did something bad and I fired him right away. I skipped all the steps. Why? You could, may be the right thing to do, but wherever possible, be consistent with what you said you were going to do and be consistent with previous actions in similar situations. I've had 9 white employees do something wrong and I wrote every one of them up, and the 10th employee happens to be black and I fire him or her. Well, that's a real good question as to why I acted one way with the white employees and another way with the black employees, and that raises an inference of discrimination. What's the effect on your EEO profile? Is it your oldest person? Is the person pregnant? Have you a replacement in mind? If you're going to replace a woman with a woman, an old guy with an old guy, a pregnant woman with a pregnant woman, that's strong stuff. If not, then you got to make sure your ducks are in a row. Seniority, that doesn't mean a thing under the law, but it means a lot to juries. If you fire somebody who's been working their tail off for you for 30 years, and now all of a sudden you're going to dump them, I guarantee you the jury's going to be looking for a reason to give that person some money. And if you don't get out of that case on summary judgment, you do not want to go see a jury. Detrimental reliance. I have a business in Miami, and I recruited somebody from Seattle. They pulled their kids out of school, they sold their house, they quit the job they'd been working at for 20 years. They get down to Miami, and 2 weeks later I fire them. Technically, probably not a violation of law, but a court will find that they relied to their detriment on your assurances of employment, and it's called a quasi-contract remedy, and they'll find some money for that person. Somebody's been out on leave or on workers' comp, and you fire them. They're going to say it's because of workers' comp. Have your ducks in a row. Termination interview. You're going to fire Sally. Rehearse. That doesn't mean write out a script and rehearse every word, but it means think through what you're going to say and anticipate what Sally's going to come back at you with, so that you will not sit there looking like a gibbering idiot when she does. Choose always, always, always a management witness. You go to fire somebody, you want to have one manager do the firing and the other manager sitting there as a witness taking notes, and after the interview, the notes get written up into a detailed statement and signed by both of you. That way, if one of you gets hit by a bus and I have to defend you, I got 2 signatures even though one is unavailable. Choose the time and place to minimize discomfort, embarrassment, humiliation. Do not fire people in the lunchroom, okay? And avoid the traditional escort by security unless it's necessary. That's a defense plan or something like that, sure. But do not embarrass people. You humiliate people, and they're looking for blood. They'll go talk to a lawyer, sure as shooting. Brief and clean, not too specific. If somebody said you're constantly late, you were late for this report by 7 days, and the employee says, no, it was only 6. Now you're arguing over nothing. Don't argue. If there's room for argument, you shouldn't be firing the person. You're delivering the final determination. Don't let them down too easy. Oh, you're a wonderful employee. I'm so sorry I had to do this. Well, then why am I getting fired? Explain any benefits. So often employers go, blah, 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 I don't know how much leave you got. I don't know when your last paycheck will get here. Make sure all of that's lined up before the interview, including if you're not going to fight their unemployment, tell them that. Get some mileage out of that. Okay, allow them to vent. He may even admit it. Good at trial. No improper comments, and don't be trapped into making them. You're firing me because I didn't learn the new computer system. Well, Brian, guys your age have a real problem sometimes with technical. Oops. You know, there's nothing wrong with saying, Brian, we're firing you because you did not learn our computer system. Well, are you saying I'm too old? I'm just saying you didn't learn it. Don't be trapped into saying something dumb. Detailed narrative, I said that. Now, let's talk about charge of discrimination. So you fired somebody or did something bad to somebody. They think it was for a prohibited reason. They file a charge. How does that work? All right. They must first exhaust their administrative remedies under Title VII and the ADA before they can file a lawsuit. This means they got to file a charge with the EEOC or a state or local human rights agency, and the agency has to investigate and reach a conclusion and issue a right to sue letter. The charge must be filed within, you can skip that 180 days, it's 300 days of the act of discrimination. So the first thing you get is a complaint from an employee that you know has been gone for a year and a half, you're probably in good shape. They can file it with the EEOC itself or with the Texas Workforce Commission Civil Rights Division, local agencies like Fort Worth or Austin Human Rights Commission. The EEOC may offer mediation. Both parties must agree, or the case goes to investigation. When do you mediate? You mediate when somebody in the process screwed up, when you have a weakness, when you have a vulnerability. Then you want to settle the case. You don't want to take a risk of losing. But if you didn't do anything wrong, and all they're trying to do is blackjack some money out of you, don't go to mediation. EEOC investigations are not in person. You submit a position statement with supporting evidence, witness statements, policies, documents, etc. They can determine no cause, dismissal, and right to sue. Most of them get dismissed. The employee must file a lawsuit within 90 days of receipt of the charge. If they find cause to believe discrimination occurred, they conciliate, and then they either sue or issue a right to sue. They don't sue all the time. They're lousy at negotiation. You can negotiate with Wage and Hour. You can't negotiate with the EEOC. They want 100%. Now, sometimes the charging party has a lawyer, and they file it, and then they ask for right to sue. They don't want to mess with anything. They just want to sue your butt, and the EEOC will frequently go along with that. Now, under age, employees must file a charge. The EEOC has 60 days to resolve through informal conciliation, conference, and persuasion. If it's not resolved in 60 days, the employee can file a suit. But if the employee doesn't file a suit and waits for EEOC, they get the same 90-day dismissal and notice of rights. Most common types of cases, direct evidence. Slack against Havens, 1975. Boss comes to the disgusting, dirty old factory. Boss comes to the employees and says, okay, all of the black employees have to clean the plant. The white employees can go somewhere else. Black employees say, sounds wrong to us. Why are we being required to clean when they're not? The boss's response, colored people clean better than white people. Now, how much analysis do you need? I mean, it's so clear from what the boss did and said that discrimination was the motive that case is over. Most cases, though, are no direct evidence or indirect evidence. Disparate impact, we talked about, Griggs versus Duke Power Company. Disparate treatment, that's the most common type. The shifting burden analysis derived from some Supreme Court cases. Basically, an employee files a charge. They must show They were a member of a protected group, they suffered an adverse action, they were qualified for the job, and either they were replaced by someone outside the protected class or treated worse than other similarly situated employees outside the protected class. Easy peasy to make a prima facie case. Then the burden shifts to the employer to articulate a legitimate, non-discriminatory reason for taking the action that they took. I fired the guy because he punched me in the mouth. Well, that's articulating a reason. I'd sure like to see some evidence, though. So even though all you have to do is articulate the reason, at this point you, or probably better your lawyer, writes out a position statement that goes over everything and demonstrates that this guy was a bad guy and had been warned for violence 20 times before, had punched 3 other guys. Here's your medical record showing you broke your nose. I mean, I'm making all this stuff up, but clearly you want to respond to the EEOC with as much evidence as possible supporting the reason you gave being the real reason and not just a pretext. Because at this point, the burden shifts to the plaintiff to show that the original reason is false and is in fact a pretext for discrimination. This means usually that the employee must come up with additional evidence of discrimination beyond merely showing that the employer's articulated reason was false. However, the court said that in certain circumstances, the mere fact that you come up with a bogus reason is enough for a jury to believe you're guilty. So if you say, I fired him because he was the worst salesperson we had, and he comes up with 5 years worth of sales figures showing he was the best, that alone could be enough to infer a discriminatory motive. So merely showing the employer lied about the adverse action could be enough for the trier of fact to conclude that discrimination occurred. I hope that's helpful. I will, as I said, stick around for individual questions, and thank you very much for your attention. Thank you.